All right, everybody, it's 5:30, and I appreciate everyone's patience as we adjusted for schedules and bills are moving uh, all throughout the Capitol today. The Senate's still in session. We appreciate that, and we had a great day on the House floor today. Before we get started with the meeting, I would like Chairman Fleming to open us up with a word of prayer. Chairman Fleming.
Please bow your heads with me. Lord, we thank you once again for all the blessings that we have, and we thank you for allowing us to be here to represent the people of this state today. We, Lord, would ask for your wisdom to be in this room now as we do attempt to do what is best for the citizens of our state. Give us that wisdom and that guidance that we need. Bless us and keep us as we move forward. Amen.
Thank you, Mr. Chairman, and I appreciate you and Chairman Epsteration for letting me rent your room for a little while this afternoon. We have put a sign-up sheet outside, and no one has signed up as witnesses today, and so we're going to move forward with just committee conversation and dialogue today, since no one has signed up. And we're going to just, it's my plan to walk you through a bill that I think is extremely important as we move forward and deal with the COVID-19 crisis. We are all should be in agreement that it's great that our state opened back up, and now it's also time for us to make sure businesses have the certainty, and our medical community has the certainty they need to move forward given this difficult environment. I will tell you that Senate Bill 359 was transferred to this committee in the hopes of us drafting a bill that would provide some immunity for our business community and our medical community. And the chair has worked diligently with them to try and craft something that I feel is good public policy and that will help our state get reopened. And we know there have been other conversations taking place in the Senate as well, but we have been working closely to try and reach a resolution on this. And maybe we did. And so I want to give us an opportunity just to walk through the bill, and I will be glad to help answer questions as we go. I'll just walk through the sections. Well, I'll let Representative Burchett, you have a question?
No, I'll wait till we get to section 3.
Okay. All right. I'm going to just start in section 1. That was some language that was submitted to us by the Hospital Association. It was some language that they felt was important as we talked to the governor's executive orders that had been issued by Governor Kemp to help our medical community have certainty as they dealt with this crisis. So that would just simply say that that these would go hand in hand with the legislation before us. All right, section 2 is pretty simple. It's just simply naming the legislation. Section 3, as you'll take a look at it, is where we begin our definitions. We've worked with parties involved to define what is a COVID-19 liability claim and also COVID-19. We've worked to include healthcare providers and healthcare facilities. Those are both, as you see, very broad definitions. As we move back through our definition of person, down on 14, we've talked about sports venue. And we may end up, the chair may end up having a suggested amendment there. Representative Carpenter, Casey, has suggested finding a way to include live music venues as well. I understand that. As the definitions in, we're looking at what we call essentially 5116.2, which deals with what I would call transmission claims of COVID-19. As you'll see, we have provided a elevated standard of care here. As you know, in almost every other negligence case in Georgia, there's a reasonable man standard. We have gone to a gross negligence standard.
Where you right now, Mr. Chairman?
I'm on line 100. $51.16.3, starting on line 105, deals specifically with how the healthcare community responded to this. And provides the gross negligence standard for them. In 51.16.4 is where we start talking about sports venues. And you'll see there we have given them also a rebuttable presumption of assumption of risk by a potential claimant, where they have some certain language included that says you're essentially assuming your risk when you come in. That was some legislation that was modeled after some agritourism assumption of risk language that we did several years ago in this committee. 51.65 came working with some of the business groups. It involves another presumption, a rebuttable presumption that they have met the appropriate standard of care, where they demonstrate something that's pretty simple. Right now, our Department of Public Health is working actually with the Georgia Chamber and Economic Development to offer essentially a COVID-19 ready certificate, where businesses can voluntarily include their get some training and go through some guidelines there. And once they do that, they'll have a certificate that says we're COVID-19 ready. And the Chamber is going to be offering some of that training, as well as Economic Development and the Department of Public Health. If they're willing to complete that voluntarily, they will get additional protection. 51.16.6 is where we talk about some jury instructions. And then 51.16.7 is largely just some clarifying language. Section 5 is the effective date and a sunset that will end on July 1 of 2021. We all recognize that we're having to do this fairly quickly, and we want to make sure that we provide an opportunity to revisit this with maybe a more substantial bill next year, and the interested parties are able to do that. All right. I'm going to take a few questions. I have had a couple of people who've now decided that they would like to sign up. So Ryan, will you go out and announce that this is a last call for anyone that wants to sign up? We'll be glad to have them on the sign-up sheet. Tell them, ask anyone that wants to sign up on the sign-up sheet. And after that, we will, that'll be who testifies today. Representative Burchett.
Thank you, Mr. Chair. First, I want to thank you for bringing this piece of legislation. This is early on in the COVID crisis. I had phone calls from constituents, and one of their main concerns was making sure that liability is limited to these businesses when all this broke out. So I appreciate it. I just had one question. I think I know what the intention was on line 37. But it's unclear to me what on the premises of any person would what does that mean? Or maybe should be on any person's premises, or.
Well, that kind of looks back to how we define person. And while it sounds a little strange, a person here can mean an individual, but it also can mean an association, institution, corporation, company, trust. And so that's kind of where.
Okay.
How we get to that.
Thank you, Mr. Chair.
Thank you. The chair would like some input and the members to be thinking through this for me to try and address Representative Carpenter's concerns for the live music venue, and what the chair was eventually going to maybe consider as an amendment would be, and I want y'all to just look at this and help me move through. It would be on line 88. We would just essentially strike the word sports. And after the semicolon that says facility on line 88, we would insert live music I don't want to say venue there, so maybe I can get some feedback from the committee, or y'all be thinking about how we would word that specifically. We would obviously have to change it throughout the rest of the code as well. Yes.
Thinking about theaters and other similar type places where spectators come to watch, but might not be captured by live music.
Performing arts space. There we go. Thank you for that, both of you. All right. We do have a couple witnesses that are signed up now. And so we will call in the first one, and that would be David Hanson with MAG. Well, come on right up here, David.
We're on lag out there. So. We used to talk about live sports venues and performances.
And most of us know you, but go ahead and just state your name for us and tell us which organization you're representing today.
My name is David Hanson. I'm here on behalf of the Medical Association of Georgia and MAG Mutual Insurance Company. I am. That'll make it easier, won't it? I'm an attorney who practices medical malpractice defense primarily. I also practice in the areas of premises liability. So needless to say, everything in here is what I'm going to be living with for the next 4 years. And so first off, I think we really appreciate the efforts of this committee and the efforts of the chair to come up with a bill that extends protections to healthcare providers, specifically, and the general business community. I think it's very important. Many other states have already done legislation such as this, North Carolina being one of the better examples. Alabama has a piece of legislation, Oklahoma has a piece of legislation, all of which have already passed, and many of them already been signed by the governor. Unfortunately, as they often say, the devil is in the details, and the details on this bill aren't quite there yet. We think the underlying goal is there to raise the standard to gross negligence, and that's what every other state has done. But unfortunately, as written, this bill has a few problems that can be fixed, but as written, we can't support the bill right now. I'll go through kind of from the beginning. The biggest problem, or not the biggest problem, but one of the problems is the definition of the word claimant. So if you look on line 26, claimant is limited to someone who is seeking recovery for bodily injury or death. That what we often see in cases is someone seeking recovery for bodily injury and then a spouse seeking a loss of consortium claim. And then they add on a emotional distress claim. And so what we've created by limiting the definition of claimant to bodily injury or death is a situation where someone is better off having their spouse bring a loss of consortium claim because the standard is lower. The damages are the same, but the standard is lower than you would for a bodily injury claim, with loss of consortium claim not being a bodily injury claim. So we would propose simply limiting claimant to recovery for damages. We don't need to limit it relating to bodily injury or for death. It should apply to all actions for damages. So that's kind of sure.
And the chair is open to something in that vein. I do have some concerns if we don't limit it in some way to breach of contract actions.
Tort actions, sure.
Tort actions.
And I think the intent of everyone is to have it apply to tort actions. and it doesn't really make a whole lot of sense to talk about gross negligence in a breach of contract sense in the first place. But as written, you've got a loophole for certain tort claims having one standard and other tort claims having another standard. The second portion of the definition of claimant that is problematic for the healthcare community is that claimant, as written at least right now, if you look on line 27, is limited to a COVID-19 liability claim. If you then look at line 34, where we define COVID-19 liability claim, a COVID-19 liability claim is really a claim for transmission. I went to the sporting event and I got COVID from the sporting event. I went to your restaurant and I got COVID from your restaurant. That's what the definition of COVID-19 liability claim is, and that's what claimant is limited to. But we then turn and use the word claimant when we get to the healthcare provision, 5116.3, beginning at line 106. That's internally inconsistent. So you've got a definition of a word, claimant, that is limited to transmission claims being used in a subsection that does not have anything to do with transmission claims. It has to do with medical malpractice claims. I think the easiest solution is just to not limit the definition of claimant to COVID-19 liability transmission claims. I think the claimant should be somebody who's bringing a tort claim related to COVID-19 and just leave it at that. And that would be able to be encompassed later in the bill through your transmission claims for your sports venues, your transmission claims for your businesses, and your healthcare liability claims for malpractice. So as written, it's not workable just given the way the definition is right now. So that's kind of just getting into one of the issues that I think this is a large bill. There's a lot of drafting going on, and just things from old versions stick in there. And I don't think that was an intent to limit, but that's kind of the way it worked out. Sure.
Thank you, Mr. Chairman. Mr. Hansen, would that simply be solved on line 26 by removing the words bodily injury or death in?
So I would just put a period after damages. Claimant is a person. First of all, I don't know why a healthcare provider is in the definition of claimant. I'm not sure that healthcare providers are bringing tort claims against people, but a person covers healthcare provider, right? I'm not sure what healthcare provider does in there, but the point is, who seeks recover or has sought.
What I was doing there is making sure that there could be healthcare providers that do want to bring a COVID-19 liability claim, and not to exclude them by doing that, by not having them specifically defined in the person definition.
Which is kind of the problem with having so many definitions, because one of the things about persons is we want to make sure that a decedent's estate is covered by claimant. But if a claimant is a person, then their estate may or may not be included in that. And then we've defined person, and person means a certain thing in here. And so the definition of claimant just needs to be the intent. Everyone understands what we mean. It's someone bringing a tort claim. As written, it doesn't encompass someone bringing a tort claim. It has these limitations and additions. And so I would put an answer to your question, Chairman Fleming, I would say basically someone who has sought recovery for damages and then related to COVID-19. Or you can delete the or and just say related to, and then delete bodily injury or death in A, and then have COVID-19. So it would read sought recovery for damages relating to COVID-19 is kind of the way you would, if you're just deleting things. That way it would then apply to the healthcare providers.
Well, what the chairman was saying about not creating a contractual claim, would it need to state an injury as opposed to clarify, or do we want to say in tort to clarify that it is not a contractual claim that we're creating?
If I remember my Georgia code correctly, Chapter 51 is titled torts. I'm not sure we need to have a secondary clarification, but I don't think it would hurt to say a tort claim. Claimant is a person bringing a tort claim. That it doesn't change anything. It just clarifies that we're not implying it to contract.
So if I may, Mr. Chairman, that would mean that you would, on line 26, after the word damages, which was mentioned earlier, add related to COVID-19 for a tort claim.
I think as we're already seeing, and we're getting into this pretty quick, we're going to have amendments that are looking to fly around and propose language. So I think what we may do is, because the chair is going to want to see them in writing to digest the full effect. So what we're going to do today is we'll take all the testimony, and I will schedule a meeting early tomorrow, and I will, or at some point tomorrow, so that we can have any amendments come in written, so that we're not trying to do this on the fly. We'll talk through this.
Yeah, I'm happy to sit here and go through it in detail, or just kind of go through the high level provisions and answer questions as they come. The next high level observation that the healthcare community has, and I say the healthcare community, I speak specifically for the people I identified, but talk to many other people, many hospitals that we represent, is that nowhere in this bill is there protection for healthcare providers for transmission claims. So kind of, I think, a quirk of the way it's drafted. There's no protection if you are transmitted COVID, if you get COVID at a healthcare facility. There's protection if you get it at a sporting event, if you get it at a restaurant, if you get it at a business. But if you're a visitor to Piedmont Hospital trying to see your mom and you've got to wear a mask, there's no protection for Piedmont making you wear a mask and going through all those protections if you bring a transmission claim against Piedmont. Because I think that's the nature of just kind of the way it's drafted. I think that's a very important thing, because I think most people can recognize the highest concentration of COVID individuals is likely going to be in a healthcare facility. They're already taking extreme measures to segregate the healthcare or the COVID patients from the non-COVID patients. I'm not sure if you've seen the news about people being able to come in and with their wife who's giving birth, one person can come in and then they can't leave. Or if they do leave, they can't come back. There's already a lot of precautions being taken to prevent the transmission in the facilities, but this bill doesn't contain any liability protection that is specific to transmission in a healthcare facility. All the transmission protections are specific in other provisions.
All right, Chairman Efstration has a question. Where are you at? What number, Chairman?
Chairman. So Mr. Hanson, could that be fixed then on line 98 by just adding healthcare facility after person, comma, healthcare facility, comma?
I think it would.
Okay. 98 after person, comma, healthcare facility. I think that's the definition or the term.
Yes, specifically
Or healthcare provider.
Healthcare facility provider. So I think you need both facility and provider,
Okay.
given the way the definitions are set up right now. But because person excludes specifically facility and provider, which we understand the intent of, I think it's just kind of an oversight of the drafting that there's no liability protection for transmission. And to Mr. Estration's question, or Representative Estration's question, I think that would fix the issue.
Okay.
The next concern that we have is specific to the liability protection contained in 16-3, so lines 106 through 114, and really specifically lines 110 through 114. The way most other states have done this is they have provided a single test. Was the healthcare impacted by COVID or the response to COVID? If so, you get a higher standard. If not, you don't get a higher standard. And that's what most people understand when they're thinking about this. If you couldn't go get a colonoscopy because you couldn't schedule the colonoscopy because COVID and nobody was doing colonoscopies, you shouldn't be held responsible for that. Similarly, if you show up with signs and symptoms of a stroke and the CT scan is being disinfected because it was being used for a COVID patient and you're not able to get your CT scan within 30 minutes as required by the standard of care, that shouldn't be held against the healthcare provider because they're sanitizing because of COVID, because they're trying to make sure you don't get COVID. So that's where most other states have gone with the language. And the language is the healthcare was impacted by the COVID response to the COVID-19 pandemic. And it's really that simple. What we've done here is we've kind of segregated out treatment of COVID patients from treatment of non-COVID patients. And we've got a few different tests that I think in many senses mean the same thing, but we don't really need to do that. We can make it very simple, like North Carolina has done. And that's a great example. Their bill literally says that you get a heightened standard of care if the healthcare provided was impacted by the COVID pandemic. And that includes your impact requirement. So you don't have care that you're going to see your PCP and getting your refill on your prescription. That's not impacted. And it certainly includes treatment of COVID patients because they're obviously impacted by the COVID pandemic. And it encompasses your patients your stroke patient who comes in, who is impacted by the COVID pandemic, but is not a COVID patient. And I think making it simpler and making it the same for all patients is a better way to do it. One of the problems with doing it this way is that COVID-19 becomes the only disease in the state of Georgia that has its own standard. Strokes don't have their own standard. Heart attacks don't have their own legal standard. Everything is negligence or gross negligence. COVID-19 then becomes singled out. And as written right now, it changes. It changes whenever the public health state of emergency begins or ends. COVID shouldn't be its own unique thing as a disease. It's the response to the pandemic which is causing this issue. And so it's the response to the pandemic where the liability protection we believe should be targeted. So we would propose simply eliminating 1 and 2 and drilling it down to the simple, the healthcare provided was impacted by the COVID pandemic. Adversely impacted. Obviously, very few things are positively impacted. I'm not sure that means anything, but it was impacted by the COVID pandemic. And we think that that gets to the point of what we're trying to do. It simplifies the bill, and you don't create problems where you have COVID as its own disease with a separate standard of care versus every other disease and every other form of medical malpractice treatment. Because what you really don't want is an ER physician who thinks, what is my standard going to be? Well, it depends on what I diagnose this person with. If I diagnose them with COVID, I'm going to have a different standard than if I diagnose them with respiratory distress and pneumonia. And that is not the incentive that we want to provide to our physicians. So that's our concern with 16-3 and our proposed solution, which is.
And I'll tell you, the chair looked at that, but I do feel it's important as we move forward to this, that it's not only showing the impact, but also that impact had some nexus to the lack of care. And that's where I felt like we struck a good balance by saying such impact reasonably interfered. I think in your example, the required CT scans and it being cleaned, I think everyone would understand that if they were doing that and that was the only reason for the delay, that would it would be clear that reasonably interfered with the normal standard of care. And that's where where I arrived at the reasonably interfered language.
Sure. And I think you could write it such that the care to the patient was interfered with by the COVID-19 pandemic. One of the things about reasonably interfered with is that's already encompassed within the nature of a tort claim through causation. Everyone has to prove causation already. Proximate cause is already a part of a tort claim. And so the problem with putting that into the language is that then the courts think that means something additional. Every time you write something, it has to mean something different than what the law already is. The law already is you have to prove proximate cause. So if the law is we have to prove proximate cause, and then we write we also have to prove reasonably interfered with, you're getting to a situation where the court doesn't know what that means. That's different than proximate cause, but under the laws of statutory interpretation, they have to interpret it differently. So putting excess language in there that everyone agrees that's what should be. You should be impacted by, you should be interfered with. Doesn't always help because it creates an interpretive problem for the courts. And so that would be our response to that, is that that's already encompassed within causation and the nature of proximate cause in a tort claim. So I think that interfered with or impacted by, which is the better term, I think, impacted by is sufficient to encompass the concerns and to address, and the concern of the chair, which is it needs to have had an impact on that actual care, is already encompassed within the nature of a tort claim through proximate cause.
I'm going to hop over to Chairman Fleming, who's been weighing, and I'll come to you, Chairman Welch. Chairman Fleming.
So how do we fix that?
I took the liberty of marking a version up myself, and what I wrote is, and I'll read it to you. On line 109, after where, I would insert the words, any response to the COVID-19 pandemic impacted the arranging for or providing of healthcare services or medical care to the claimant. And that actually uses a lot of the language that's already there. Really, all you have to do is add the words, any response to the COVID-19 pandemic impacted after the word where, and then you actually kind of leave the beginning of one and leave that through the word claimant and then put a period at claimant and then eliminate the remainder of 1 and 2.
What about
And-
B?
B remains. B is what sets the standard. It's just 1 and 2, combining it into one standard. And so it would read, where any response to the COVID-19 pandemic impacted the arranging for or providing of healthcare services or medical care to the claimant. And therefore you have one standard that applies to all diseases, that is workable, that incorporates proximate cause within it and incorporates the impact requirement. We're not raising the standard of care for all medical care. It's just if it's impacted.
Thank you.
Would you have a problem if we still put in something about proximate cause?
I wouldn't have a problem if you say they still must prove proximate cause, because I think that's already what the law is. I think the problem is using words other than proximate cause, because then the courts interpret them to mean something different than proximate cause, if that makes sense. If you use reasonably, if you use, what was the language that you proposed, reasonably interfered with, the courts are going to interpret that to mean something different than proximate cause. I think it would be perfectly acceptable to say that proximately caused injury, because that's already what the law is. If you want to insert proximately caused injury somewhere in there, and I can't say off the top of my head where it is, that's already the law. Okay. And you clarify that. And so when someone reads it, they understand what it is, especially a non-lawyer who doesn't know, I already have to prove duty, breach, causation, and damages. I mean, I know that, you know that, but the lay person reading it may not. So if you want to say that was proximately caused by, that's a reasonable, I think the reasonable way to do it. The only other comment that we had, broadly speaking, is in Section 5, the sunset provision. I think we certainly understand the desire to revisit this next year if we want to continue it or what have you. As written, this expires and is repealed before the statute of limitations runs, which doesn't make any sense, because then you just wait until the statute until this expires, and then you bring your claim, and none of these protections still apply. So I think if you're going to have a sunset provision, which I don't have a problem with, it should stand repealed after the statute of limitations runs for all the claims that we've got right now. And because of the way the judicial order is written right now, all claims are told. And so the statute of limitations isn't going to run on a claim that exists right now until, until July 14th, 2023. Now that, okay.
7, Michael Vick's number. Well, I'm just disappointed because I thought we got paid by the word, and he's just canceling word after word after word. So that was my earlier comment, but actually more substantive comment was, I do not want us to use a repealer after the statute of limitations runs. We need it to be a date certain. So I understand conceptually what he wants to do, but I think that the statute of limitations would be 2 years in a medical situation, right? And then
correct.
So 2 years from the effective date of the bill, that makes sense to me, but not because each circumstance may be different is when that actually when the statute starts to run on the claim. So we could have a claim that comes up literally the day before that then would actually prolong the existence of the bill beyond what we contemplated.
So
Do you follow what I'm saying?
I do, and I actually think what you're explaining is covered in Section 4 on line 159, where the bill states what causes of action it applies to.
Mhm.
A cause of action accruing until July 1st, 2021. So the problem with it as written is it applies as written until a cause of action that accrues. So you can be harmed on June 30th, 2021. But then the bill is repealed the next day. So none of these protections apply because the bill was repealed. And I think it's about the repeal of the bill has to be tied to the statute of limitations. So 2
Yes.
years after that. But
Right.
keeping,
So
we don't
it's
have a problem.
It'd be a 3-year window, effectively.
It's a 1-year window for the claim to accrue, and then the existing 2-year window for the claim to be brought, which is not a change in the law. Technically, we need to go to July 14th because the judicial order extending statute of limitations through July 14th, everything's told through July 14th,
Which might get extended again.
which may get extended again. You may want to tie it to the extension of the, you might want to tie it to that as opposed to tying it to a date certain.
Well, I think the author's intent is to create a very narrow window.
And to revisit, I
Yeah.
gave the parties my word to revisit this next year as we see it develop.
So I think that, I want to stay with that line of thinking and not broaden it. And so that's what I was trying to get at.
And our comment is simply that the narrow window is created by line 159, and that unless we change line 162, the bill basically means nothing
But-
because it doesn't exist anymore from that date forward. So you don't get, so for example, I have a claim right now. Okay. It, by the language of this, it applies to this cause of action. I hire a lawyer and they say, well, here's what we're going to do. We're going to wait for 1.5 years because we can. And then this bill will be repealed and we don't have to comply with any of these provisions and we'll bring the lawsuit then. That's the kind of thing that, as written, when it is automatically stands repealed, creates disparate interests, and it creates weird incentives for people in terms of bringing their claims. There's no problem with limiting it. We don't have a problem with limiting it in time. We don't have a problem with limiting it in time to July 1st of 2021. It's just that by then repealing the bill the same day, you're actually limiting it in time to not be in anything at all because it gets repealed.
So does the statute of repose alter that? If we included that,
The statute of repose, the 5-year statute of repose wouldn't really come into play even under what we're proposing, which is to have the bill be repealed 2 years after the date that the last claim can accrue,
Right.
which is what, they have 2 years to bring the claim from the date it accrues, and the bill should be repealed 2 years to the date after the claim accrues, which is saying this applies to anything that accrues, and then you have your standard 2 years to bring it.
yeah, that makes sense to me. And so that's why I'm asking these questions, to try to flesh that out a little bit more. And there's nothing to prevent us from revisiting this anyway without having a specified date. But I do think, to the chairman's point, having a confined period of time based upon Section 4 and then setting out your repealer that would mean 2 years thereafter makes sense, and it's consistent with when a claim could be accrue and then would have to be brought.
I don't think we're disagreeing.
We're not.
I think we're simply saying that as July, the line 162 2021 needs to be changed to 2023 in order to put into effect what we're talking about, which is you have 2 years after your claim accrues to bring it.
July 15th.
Yeah, and moving it to July 14 as written as right now. If you want to say that it's triggered based off of the extension of the Supreme Court's judicial order, which I don't think is going to be extended. Justice Melton has created a panel about that, but he's already issued guidance on the resumption of tolling and resumption of deadlines beginning July 14th. So I'm pretty sure July 14th is going to be your date, but I can't speak for what's in Justice Melton's mind. Those are the concerns, and I appreciate everyone's time. I'm happy to answer any more questions, but I'm sorry to take up all this time. And sure.
Sharon, thank you. Could we look back at line 25 and just go back to some discussion that was happening earlier? If we said that the claimant meant a person, and then we got rid of healthcare provider, and then we said that that in line 26 seeks or has sought recovery for damages in tort for the transmission of COVID-19, as opposed to the relating to. It keeps it very direct.
So the problem with saying related to transmission of COVID-19 is that you use the word claimant in the med-mal provisions in lines 106 through 117. And that's not limited to transmission. That is addressing medical malpractice. So if you include transmission in the definition of claimant, you've got an internal inconsistency there.
And then, Mr. Chairman, the other thing I was going to suggest was instead of using the word person as a defined term at line 64, maybe we use the word entity and remove the word individual from that. We know what a person is, but and then we'd say entity and strike the word individual in that definition.
Thank you, Mr. Chairman. My question goes to our discussion on section 4 and section 5. Section 4 says this act shall apply to all cases, all causes of action accruing until July the 1st, 2021. How could a cause of action accrue after that?
Cause of action.
This act shall apply to all causes of action accruing until July the 1st, 2021.
Correct.
How could a cause of action accrue on July the 2nd, 2021?
I mean, any cause of action could accrue on any day. It just wouldn't be subject to the provisions of this bill. I mean, somebody could treat a COVID patient that comes in on July 2nd, right? If somebody gets COVID, doesn't get the vaccine, let's assume, God willing, there is one, comes in on July 2nd, a cause of action relating to COVID accrues on July 2nd. They just don't get the protections of this bill beginning on July 2nd.
But our assumption is that's not important because the virus will have played itself out or we'll have a vaccine by then, correct?
That's correct. I think that goes to the chairman of the committee's concern about making this a limited in time through any cause of action through July 1. The theory being hopefully COVID is under control by then. And if it's not, when the legislature meets next year, maybe change section 4 to say 2022 instead of 2021.
So, Mr. Chairman, we've got somebody here who's made a lot of sense on this issue, and I wanted to flesh it out while he was still here. So it seems to me getting rid of section 5, because what you want is a conference in section 4. You're limiting this code section by section 4 there.
Let me check legislative council, but I understand that concern.
Okay, thank you.
All right. I don't see any other questions either in the room or on our Zoom. So thank you for being with us, David.
Thank you, Mr. Chairman. I appreciate the time.
You can.
I'm happy to. Make him stay. Don't let him go.
Ryan, will you bring in Nathan Humphrey? Well, actually, Senate rules is meeting and the chair has to be before them, and I don't know if any other members has to be. Does any other members need to be before Senate rules? This committee can stand at ease so that we can go hopefully get our bills out of the Senate. All right, everybody, we're going to get started again. We're going to continue with our witnesses. Ryan, can you get Nathan Humphrey in here for us? As he's coming, I'll just say I appreciate everyone being patient as I went and looked to get a bill out of rules. Come on up, Nathan. And we'll get started. If you'll just state your name for us and tell us which organization you're with.
Good evening, Mr. Chairman, members of the committee. My name is Nathan Humphrey. I'm with the NFIB, the National Federation of Independent Business. We represent just around 7,000 small businesses here in the state of Georgia. And I appreciate your efforts and work on this important issue to protect small businesses. So we've done a couple surveys of our members recently since COVID-19 hit, and one of the top priorities that have come out of that survey shows that small businesses are concerned about liability issues around reopening their businesses. And as you know, small businesses have had a lot of challenges trying to go through the PPP process for funding and just make sure they have got PPE so they can comply with all the guidelines that are coming out. So it's a challenging time for them without this. And they're just concerned that they don't want to see, COVID-19 weaponized into opportunities for frivolous lawsuits and shakedowns. So I appreciate your efforts on this. I just want to emphasize how important the issue is and to our members. And thank you again for taking the time to look at it. We have just recently sent the draft, the most recent draft you sent us to legal counsel to review. So I can't really provide a whole lot of thoughts on that until I get those comments back from our legal counsel. So hopefully we'll have that for you tomorrow morning, and I can speak more definitively on some of the changes. One piece that I can speak on is at the bottom of the bill. There's a section on the certificate program that would be put on through public health. I do have concerns about that specifically. We feel like that would be an additional mandate and burden put on the backs of small businesses that they would have to comply with. Another, basically a tax on them. We believe that small businesses that are making a good faith effort to comply with the guidelines is plenty enough for them to have the presumption that they are doing everything possible to take care of their employees and their customers.
Chairman Fleming.
Thank you. And I want to make sure I understand. What is it you don't like again?
At the bottom of the bill, we just have some concerns about the and I apologize, Mr. Chairman, I didn't have the bill in front of me. The certification program that would be put together by the Department of Public Health. Oh, I apologize. Yeah.
And what is not satisfactory about that?
We just don't feel like an additional loophole and mandate on businesses is necessary. They've got so many, most of my members are, they're CEO, CFO, head of HR, and now they're head compliance officer. So to add an additional burden on them that they need to get another certificate and spend more time going through an education class, it just seems a little burdensome to me.
What about the second part of that a person complied with guidelines that were in effect at the time of the occurrence of the alleged infection?
I'm sorry, Mr. Chairman, which line is that?
It's 146. That's a two-part test as I read it, Mr. Chairman. You may correct me here. You got to do two things to
Correct.
get this rebuttable presumption that you're not liable And you got to do a program with Department of Public Health, and then you have to have complied with guidelines that were in effect at the time of the occurrence. Do those guidelines refer back to the first number one there? It can't, because the two don't happen at the same time. What does that refer to on line 146?
Where it's defined on line 47, guidelines and regulations related to COVID-19 issued by the Department of Public Health.
Oh, in other words, with the governor's executive orders, they told you to do this, and if you did that, then you get a rebuttable presumption that you are not liable for the infection.
Yeah, that you have the appropriate standard of care.
So is it that part you have trouble with, or is it the first part on line 143?
The 143. It just opens up a lot of questions on what standards and education are we talking about. The guidelines have changed day by day, even through CDC and public health. So
If I may, Mr. Chairman, does this program referred to in line 143 currently exist, or is something we expect to be developed?
It is something that's my understanding is being
Currently developed.
currently developed.
Okay, and then your point is you represent a lot of small businessmen, mom and pop shops,
correct.
and that for them to have to comply with that would several of them are probably going to do it. Is that what it amounts to?
Correct. I just think it's an additional hurdle for them. I don't think that that should be something they would need to do to get the immunity protections that we're asking for. I think that a good faith effort that they can demonstrate their follow the guidelines is enough to do that.
I think I understand the spirit behind that in line 143.
Yeah, I think the intent is
it would be
is
great
fantastic.
if it did do it.
It's the intent is fantastic, and I will say that we have been in talks with the Department of Economic Development to put together a program like this, but it is more of a way to boost consumer confidence, to show that, hey, we're following. A business can get a sticker and highlight the fact that they are following, the guidelines that have been put out. And it's basically just a pledge and promise that they're following the law, and they can promote that to help customers come in with some confidence. Because the other thing I would say, that in addition to liability concerns that our business members responded back to in the surveys, there's one, giving their employees confidence to come back to work, and getting employees to come back to work. Two, giving their customers confidence to come back to their stores. So all those things I think are kind of tied together. But so I know it's late. I won't take up your time, Mr. Chairman. That's the only piece that I can really speak to definitively right now. And I hope to give you some more definitive comments on the rest of the bill as early as I can.
Thank you. No further questions.
All right, thank you.
Rob, thank you for being with us. Will you just state your name for us and tell us who you're here representing tonight?
Yes, sir. Thank you, Mr. Chairman. My name is Rob Fortson. I'm here on behalf of the Community Association Institute, which is of Georgia, which is the state organization that represents community associations, condominium associations, homeowners associations, property owners associations. So I just wanted to come and state our support for the bill and for the effort. We appreciate what you're doing. There was one requested edit we had.
Okay.
We are referenced at line 93, but I believe it just, and I apologize, I don't have a copy of the bill in front of me, but, oh, great, thank you. Appreciate it. So at line 93, it refers, I believe, just to the property owners associations. So, and just to swimming pools. And so the way it lays out in Georgia is you're under the Property Owners Act, the Condo Act, or you're a Homeowners Act, a homeowner association, just a common law. And the biggest group in terms of swimming pools would be the condos.
Okay.
So and there are other amenities, tennis courts and fitness centers and things. So our request would be that it simply state, or amenities, make sure I get it right.
And if you want to kind of give us the idea, you can give me
Sure.
the written language.
submit it, yeah,
so-
so-
for you. That may be easier to see. I see what you're asking for.
Yeah.
Don't have a problem with that.
Okay, great. I'll submit it. It's just just to say it is amenities of community associations, but I'll put that in writing. and send that to
Amenities
y'all.
of
community
communities.
associations.
All right.
Yes, sir.
Thank you so
Thank
much,
you.
Rob. We
Appreciate
appreciate y'all's support. All right. And final witness, Jordan Reed. All right. Scott with the Dental Association. Grab him real quick. Grab Scott. Hey, Scott. Scott, I appreciate you being with us. Will you just state your name for us and tell us who you're with?
Yes, sir. Thank you, Chairman Kelly, for allowing me to speak. My name is Scott LaFranco. I am the General Counsel and Vice President of Government Affairs for the Georgia Dental Association. We represent over 3,500 member dentists, roughly 70% of the licensed dentists in Georgia. I will keep my comments brief because I just saw the sub this afternoon or the language that was proffered before you guys broke. I do share some of the concerns that were raised regarding the transmission issue with respect to the healthcare provider. And I agree with some of the sentiments shared regarding the sunset provision and how it needs to be tied to the statute of limitations, if you will. I understand that you have made the commitment to work forward with the healthcare organizations. So I just wanted to be on the record stating, our thoughts about the proposed language, and we look forward to working with you as this moves forward. I'll be happy to answer any questions.
Thank you, Scott. I appreciate you. We have one for you from
Okay.
Chairman Fleming.
Yes, sir.
Thank you for being here today. Did you hear the discussion earlier?
Yes, sir.
With
I watched it.
Counselor Hanson.
Yes, sir.
Okay, and so assuming whether you're dental or doctor, it's all the same as far as the language. Is that right?
Yes, sir. The concerns are the same that were raised, and I think you made some strong points as to some of the concerns you raised, and we would be in agreement with that.
So whatever changes we make is going to affect dental or doctor,
Absolutely.
for
Yes.
lack of a better description.
Yes, sir.
Okay, we don't need to single the word dentist out.
We're in the bill. We got included in the definition of healthcare provider, so
Okay.
we are included in both the provision of healthcare services.
Thank you.
Yes, sir. Thank you. Well, thank you for your time. I appreciate it.
Thank you, Scott. We appreciate you being with us and for all y'all do. Now get Jordan. All right, Jordan, if you'll state your name for us and tell us who you represent.
Hi, I'm Jordan Reed with the Georgia Trial Lawyers Association. Thank you, Mr. Chairman, for allowing us the opportunity to talk about the bill. We're here to work together on creating a great bill to make sure that Georgia can keep the economy going and get back to work and all. And so to that end, I just want to address some of the concerns that were raised very briefly. First off, in terms of structuring and the term claimant, that actually comes from the ER statute. So this is very similar to the structure and language that's already codified in Georgia law that we have for our hospitals. So to that end, I think a lot of the solutions can be found if we simply go to the code section starting at line 30, where it talks about, line 34, where it talks about a COVID liability claim. And if I could direct the committee's attention to 51.16.3, starting at 105 to 117. We can take that language and make that another form of a COVID liability claim. And then it solves all the problems that were discussed because it ropes back in if we use Chairman Kelly's language. There may be some slight tweaks that are needed to it for everything to flow properly. And I'm happy to provide that with all the written requests are taken. And lastly, at lines 51.16 to starting at line, 97 to 104. where there's discussion that healthcare facility and healthcare provider maybe should be included. Yes, if we put them in, and that creates all of the solutions for the COVID liability claim discussion, simply because if you look, it says shall be immune from liability, line 100, for the actions by the person or sports venue, and we include healthcare facility, healthcare provider, showed gross negligence, and therefore they have the negligence immunity. To that end, I don't have much further unless the committee has questions for me. Oh, one last thing. Section 5, there's discussion about the date. It's only repealed for claims that accrue after the repeal date. So this just means that any claim that accrues after the repeal date wouldn't get the protections. Structurally, I believe Chairman Fleming would be correct, but like we often say, belt and suspenders, it's best to have everything buttoned up, tightened up, not leave any ambiguity. That's also why we talk about reasonableness when we talk about infection in the other section. There needs to be a nexus. We can't just rely on an assumption that there's a nexus.
Ms. Reed, did you hear some of the discussion I think raised by Chairman Welch, where we talked about tweaking the definition of person? I think Chairman Welch was kind of going in the vein of replacing person with entity, and then strike individual. I guess anywhere we needed to reference an individual, we could say an individual, entity, healthcare provider, or healthcare facility as it tracks through.
So person would become its own category, and then entity would be its own category.
Well, I mean, we wouldn't have to define person, I don't think.
You would just say it as an individual.
Yeah.
Individual, entity, healthcare provider, healthcare facility.
As you're naming off the different groups that would get, as you move through it.
It sounds good to me. I mean, I'd have to see it all together, but that seems to make sense.
So line 64, just strike the word person, insert entity in lieu of person, and then strike the word individual. And then you've got entity covered by all of this.
Now yes, but the one thing I would want to double check though is potentially healthcare facility might have the word entity. And if you don't want healthcare facility to also mean entity in that context, that would be the one hesitation. But looking at the draft provided by Chairman Kelly, I don't see entity there. So again, I think you're right that would work.
Okay. Thank you. You have a question from Chairman Fleming.
Thank you, Mr. Chairman. Mr. Reed, on the issue of Section 5, which is lines 161 and 162, in our earlier discussion, it was said that if you simply wait until July the 2nd to file your lawsuit, July the 2nd of 2021, then it nullifies everything that we would have passed.
I disagree with that statement because of Section 4. And also we have other statutes that when it talks about a claim accruing, it applies for that. And simply because it's no longer on the books, like simply because you went on LexisNexis and you don't see it for that date and time doesn't mean it doesn't still apply to you when the cause of action accrued.
So you're saying if the code section stands repealed on July the 1st, 2021, it's not repealed?
Not as it applies to the actions, because how we have the record of the previous forms of the Georgia Code. So for instance, when you look at, unfortunately, this is the only act that's coming to mind right now, the Hidden Predator Act. When you look at the way, if you were to sue an individual, there was a time frame you could do it, and then it's disappeared since then. But if you fell within the window of when you could have brought the cause of action, just because you no longer, say, Googled it and didn't see it there, didn't mean you couldn't still bring a cause of action as an individual for that limited time. Currently, you can't for an individual, but there was a time you could.
So you're saying Section 5 is not a statute of repose is what you're trying to argue?
I think that's a fair assessment.
And I just would wonder if it is, and would want to know before we made it one.
If it gives you pause, I think Section 4 is sufficient, though.
Okay. The last question I have, Mr. Chairman, relates to the fact that we have two attorneys, Mr. Hanson and Mr. Reed, both proclaiming, and I believe them, to want to accomplish the same goal. They just disagree at how the language does that. My request would be for you to consider having them work with each other and see if they can agree upon the same language. Because if they can, it makes it very easy for us. Thank you.
Like the easy button.
So they're not allowed to go home or, get anything to eat until they work this out, is what I heard the chairman say.
I think you told me to stay here, right?
Yeah. They can use this committee room. I'd be happy to allow them to do that.
That would be for the betterment of all Georgians.
That's right.
Whatever I can do to help the committee.
All right. Well, thank you so much for being with us, Mr. Reed. We appreciate that. And I would, if you and David could talk together, and I know that some of the hospitals have a in-house counsel as well, that they'd like to be in the loop. Y'all try and work where we can and bring the areas of disagreement to me, and I'll be glad to try and be Solomon.
Thank you. Thank you for your time. Thank you.
Again, I appreciate everyone staying here and working here. This is an important committee with important work to be done. Given the late hour, we're going to wrap things up. I'm going to work on getting a time for us to meet tomorrow. What I am going to do, though, is I'm going to ask for any amendments to be provided to me in writing by 11. I would also love to see if we're able to get any agreement for me to have those as well. But by 11 a.m. tomorrow for consideration for those to be submitted in writing to the chair. I'll work with y'all.
The only reason I say that, Mr. Chairman, it'll be helpful to see it all in one package.
That's right.
And then I might be able to see where I'm tweaking.
I agree with that. Absolutely, Chairman Welch. Thank y'all so much. We'll stand adjourned.
Thank you.